The Supreme Court just issued a 9-0 unanimous decision striking down the anti-gunners' attempts to shut down the firearms industry nationwide. And this was a big decision, a big win for the 2A community. So let's break down what just happened. Now, before we jump into this video, I want to thank one of the sponsors, which is Home Title Lock. Now, one of these scary things with everything that's going on right now with the development of AI and a lot of cybersecurity issues is you really don't know what, new scammers are doing, all the new technology that they're using to, weaponize against you. You could be doing everything you think is absolutely right, but now with all this new scary technology, you could be the target of these AI scams. And one of the new things that they're doing is they're targeting your home title. Here's how this works. They forge your signature on one document, use a fake notary stamp, pay a small county fee, and just like that, your home title is transferred out of your name. And they can take equity out of your home. They can use loans against your home. And your home could go into foreclosure before you ever even know what's going on. So let me ask you, when is the last time that you checked your home title? If the answer, like me originally, was never, this might be something you want to take a look at. But one of the things you can do, just like we recommend defending yourself here on the channel using, firearms and all those things, you can do other things to also protect yourself on the financial end of things. So if you're interested, check out Home Title by using the link down below. And if you use the promo code ARMSCHOLAR and you go to HometitleLock.com, you will get a free title history report and a free 14-day trial of their $1 million triple lock protection. And that includes 24/7 monitoring of your title, urgent alerts if anything ever happens to your home title. And if fraud does happen, they will spend up to $1 million to fix that problem for you. So again, go to HometitleLock.com using the link down below and use that promo code ARMSCHOLAR to get all those free additional promos. As I mentioned in the intro, in this video, we're going to be breaking down a significant Second Amendment case which the Supreme Court just issued a 9-0 unanimous decision in. This was a big win for the 2A community, and it came in a case called Smith & Wesson versus Mexico. In this case, a group of the largest firearms manufacturers, including Smith & Wesson, Barrett, Century Arms, Colt, Glock, Ruger, and many more, were sued by the nation of Mexico. Mexico sued these companies in an attempt to hold them liable for harms that were caused by cartels in the nation of Mexico. This whole case revolves around the PLCAA and whether or not the nation of Mexico and potentially others could sue gun companies in America and try to hold them liable for criminal conduct that happened by third-party, individuals and criminals and other individuals like that. If Mexico was able to do this, the floodgates would open up and there would be a ton of lawsuits against the gun industry in America. But fortunately, this case was even so far out of the bounds that even the liberals in the Supreme Court, all those justices, sided with the 2A side, and they issued a 9-0 decision striking down this lawsuit by the nation of Mexico. And they essentially upheld the PLCAA and said that the PLCAA does bar these types of lawsuits. The opinion was written by Justice Kagan, and then there was a concurring opinion by Justice Thomas and Jackson. Now, this case made its way to the Supreme Court because the First Circuit Court of Appeals reversed a dismissal of this case. The Mexican government sued leading members of the firearms industry in America, was trying to seek and hold them liable for harms inflicted by Mexican drug cartels. And according to the nation of Mexico, these American firearms companies have engaged in a series of business practices for decades, from selling AR-15s and other types of magazines and other types of firearms, and that those imposed harms to the nation of Mexico because they were used by drug cartels and it caused, harms to the nation of Mexico. In this lawsuit, Mexico sought to hold the American firearms companies liable for those harms caused by cartels in their own nation. And they wanted the suit to proceed forward. And they also wanted, to get payment back from these gun companies. Around $238 billion is the damages that they claimed occurred, and they wanted about $10 billion in compensation. They also asked for injunctive relief in the form of America and these companies imposing new gun control measures in the United States to ban and restrict these types of sales of rifles and magazines. Like I mentioned, this case was originally filed in a federal district court in Massachusetts, and on review, that federal district court dismissed the case, saying that the PLCAA barred these types of lawsuits. However, this was then appealed by Mexico to the First Circuit, and the First Circuit said that these types of claims and these allegations could proceed forward. That then led for this case to make its way to the Supreme Court for review, and the Supreme Court reviewed this case, and they found that no, the PLCAA does bar these types of lawsuits. They issued a 9-0 unanimous decision striking down this lawsuit. In the majority opinion authored by Justice Kagan, the Supreme Court held that because Mexico's complaint does not plausibly allege that the defendant gun manufacturers aided and abetted gun dealers unlawful sale of firearms to Mexican traffickers, the PLCA bars the lawsuit. In the opinion, the court finds that the gun dealer's actions do not fall within the PLCA's exceptions, and that Mexico has failed to show that the dealers aided and abetted in the criminal conduct that was alleged. The court stated that Mexico's complaint does not plausibly allege that the defendant manufacturers aided and abetted gun dealers' unlawful sales of firearms to Mexican traffickers. To begin, the complaint sets itself a high bar. It does not pinpoint, as most aiding and abetting claims do, any specific criminal transactions that defendants allegedly assisted. Instead, it levels a more general accusation that all the manufacturers assist some number of unidentified rogue dealers in violation of various legal bars. The systemic nature of that charge cannot help but heighten Mexico's burden. To survive, it must be backed by plausible allegations of persuasive, systemic, and culpable assistance. Mexico's lead claim that the manufacturers elect to sell guns to, among others, known rogue dealers fails to clear that bar. For one thing, it is far from clear that such behavior without more could ever count as aiding and abetting under the court's precedents. And in any event, Mexico has not said enough to make its allegations on this point plausible. It does not confront that the manufacturers do not directly supply any dealers, and its complaint does not name any alleged bad apple dealers or provide grounds for thinking that anyone up the supply chain often acquires that information. What Mexico has plausibly alleged is only that manufacturers know some identified dealers routinely violate the law, but this describes indifference rather than assistance. For related reasons, Mexico's second set of allegations that the manufacturers have declined to suitably regulate the dealers' practices cannot fill the gap. Of course, responsible manufacturers might well impose constraints on their distribution chains to reduce the possibility of unlawful conduct, but failure to do so is what the Twitter case called passive nonfeasance. Such omissions and inactions, especially in an already highly regulated industry, are rarely the stuff of aiding and abetting liability, and nothing in Mexico's allegations make them so. Finally, Mexico's allegations about design and marketing decisions add nothing of consequence. Mexico's focus on the production of military-style assault weapons, but these products are widely legal and purchased by ordinary consumers. Manufacturers cannot be charged with assisting criminal acts simply because Mexican cartel members also prefer these guns. The same applies to firearms with Spanish language names or graphics alluding to Mexican history. While they may be coveted by the cartels, they also may appeal to millions of law-abiding Hispanic Americans. Even the failure to make guns with non-defaceable serial numbers cannot show that the manufacturers have joined both mind and hand with lawbreakers in the manner required for aiding and abetting. Now, this section is also very interesting because you have Kagan here writing for the majority, and she's essentially admitting that AR-15s and similar firearms are owned and picked by millions of law-abiding Americans, and that is significant for future rifle ban cases going forward. She goes on to state that the conclusion aligns with the PLCA's core purpose. Congress enacted the PLCA to halt lawsuits attempting to make gun manufacturers pay for harms resulting from the criminal or unlawful misuse of firearms. Mexico's suit closely resembles those lawsuits. And while the predicate exception allows some such suits to proceed, accepting Mexico's theory would swallow most of the rule. The court doubts that Congress intended to draft such a capricious way out of the PLCAA, and in fact, it did not. Therefore, they reversed and remanded what the First Circuit said. Now, Thomas in his concurrence wrote that the court today correctly decides that Mexico has not plausibly pleaded that this suit falls under the predicate exception for the PLCAA. This exception allows otherwise prohibited suits against gun manufacturers to go forward if, among other requirements, the manufacturer has knowingly violated a state or federal statute applicable to the sale or marketing of the product. I write separately to note that the court's opinion does not resolve what a plaintiff must show to establish that the defendant committed a violation. It concludes only that Mexico has not adequately pleaded its theory of the case, that as a factual matter, the defendant gun manufacturers committed criminal aiding and abetting. In future cases, courts should more fully examine the meaning of a violation under the PLCAA. It seems to me that the PLCAA at least arguably requires not only a plausible allegation that a defendant has committed a predicate violation, but also an earlier finding of guilt or liability in adjudication regarding the violation. Allowing plaintiffs to proffer mere allegations of a predicate violation would force many defendants in PLCA litigation to litigate their criminal guilt in a civil proceeding. And he has concerns that this could also include gun companies and other companies that have already been cleared in other cases and other proceedings of not violating or not being liable at all, but these kind of broad allegations that could be brought could still leave them on the hook if that is all that is required. So it was a very important case to solidify that these types of challenges do in fact violate the PLCA, that they cannot be brought. But I'm sure anti-gunners will not stop to try to skirt the PLCA. They're going to try to come up with other ways to bring these type of challenges and maybe still believe that they can bring broad allegations and litigate these issues going forward. However, it was good news that the Supreme Court issued a 9-0 unanimous decision finding that Mexico could not bring this type of lawsuit and that the PLCA does in fact bar this challenge. So good news in this case, again, a 9-0 unanimous decision, kind of one of those rare ones that you see where the court joins together, especially in a firearms case. Good news going forward. As we get more information, as this develops, and as we see this trickle down into other challenges, I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And don't forget, this station was built by Arm Scholars, and the station will be maintained by Arm Scholars.